On January 11, 2026, in the 28th Circuit Court for Wexford County, Michigan, defendant Mr. Nelson appeared before the judge for sentencing on multiple matters. The proceedings involved a global resolution between two cases, a new felony drug charge, Case 24-14199 for possession of amphetamines, and a probation violation from a prior case, Case 24-3314H. The incident stemmed from Nelson's alleged continued drug use and absconding while on probation, culminating in his arrest and the discovery of controlled substances in his possession.
Counsel, I assume you're going to be the one doing the talking today. Is that a complete and accurate statement of the pretrial agreement to resolve file 199?
Yes.
Thank you.
Your Honor, I really apologize for interrupting, but there was one more aspect to the global agreement. It was that the people were not going to file the assault and battery charge. That was pending review. That was one of the probation violations.
All right, Mr. Nelson, have you heard what these ladies have told me today?
Yes, Your Honor.
Is that how you wish to resolve this other file?
Yes, Your Honor.
All right, thank you. Please raise your right hand the best that you can. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. All right, sir. So in this newer file, I understand, and obviously we've already dealt with the fact that you were on probation when it occurred, and we've already dealt with that prior probation violation. So in this file 14199, you are currently charged with a single count of possession of the controlled substance amphetamines, which is an analog, not methamphetamine, but amphetamine. Well, that's a felony punishable by up to 2 years and or up to $2,000. Plus, there were two potential sentencing enhancements that could increase those maximum punishments within the discretion of the court if you were found guilty of those. A second or subsequent drug offender enhancement could increase that maximum punishment from up to 2 years to up to 4 years, and from up to $2,000 to up to $4,000. Or in the alternative, you could be sentenced as a fourth habitual felony offender. That would allow the court within its discretion to sentence you up to 15 years instead of 2.
The judge begins the plea colloquy by confirming the negotiated agreement between prosecution and defense, then administers the oath and outlines the original charges against Mr. Nelson, including potential sentencing enhancements that could dramatically increase his maximum exposure. Under Section 333.7403 of the Michigan Public Health Code, possession of amphetamines is classified as a felony punishable by imprisonment for not more than 2 years or a fine of not more than $2,000 or both. The statute distinguishes between simple possession and more serious offenses like possession with intent to deliver or manufacturing. Additionally, Section 333.7413 provides for sentencing enhancements as a second or subsequent drug offender, which can double the maximum fine to $4,000, while Michigan's habitual offender statutes under Section 769.12 allow fourth felony offenders to be sentenced up to 15 years for what would otherwise be a 2-year maximum offense. The judge meticulously outlines these enhancement possibilities to Mr. Nelson to ensure he understands what he is avoiding through the plea agreement. By pleading guilty to the reduced charge of use of a controlled substance, a misdemeanor under Section 333.7404, Nelson escapes the felony conviction and the dramatic sentencing exposure of 15 years that the habitual offender enhancement would have permitted. This charge reduction represents a significant concession from the prosecution, typically granted in exchange for resolving multiple cases or avoiding trial. Plea bargaining is the engine of the American criminal justice system, with over 90% of felony convictions resulting from negotiated pleas rather than trials. Understanding the sentencing enhancement statutes is crucial for defendants because these provisions can transform relatively minor offenses into decades-long prison sentences. The judge's detailed explanation ensures that Nelson's waiver of his trial rights is knowing and voluntary, protecting both the defendant's due process rights and the finality of any conviction.
However, that count, possession of possession of amphetamine, and the two enhancements will be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 2. Added count 2 would be use of that controlled substance, which is a misdemeanor punishable by up to 1 year and or up to $1,000. Is that what you understood you were doing today?
Yes, Your Honor.
Now, entering a plea of guilty to this added count 2 means that you will not have a trial. Does that make sense?
Yes, Your Honor.
If I enter that plea, if I accept that plea, again, you'll be given up these certain rights: the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent, the right to have the prosecutor prove your guilt beyond a reasonable doubt, the right to have the witnesses, the right for you to question and cross-examine any witnesses who appear against you, the right to have the court order any witnesses you need to appear for your defense at the trial, the right to remain silent in the trial, the right to not have that silence used against you, and the right to testify if you chose to. You understand those rights?
Yes, Your Honor.
And even more importantly, you understand that by pleading guilty, you'll be waiving those rights and not have a trial in this case?
Yes, Your Honor.
All right. Leading me to believe that I missed one of the rights. The right to be presumed innocent until proven guilty, the right to have the prosecutor prove your guilt beyond a reasonable doubt, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses. Again, you understand all that?
Yes, Your Honor.
And again, you understand that if you enter a plea of guilty, you'll be forever waiving those rights as they apply to this particular case.
Yes, Your Honor.
Also, you'll be any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right, which is only allowed when you're convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements that we haven't talked about?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, throughout this process, have you been able to speak with Ms. Castles or Ms. Getz?
Yes.
Have they answered all your questions?
Yes, sir.
Are you satisfied with their advice?
Yes, sir.
And do you believe that this plea is in your best interest today?
Yes.
The judge continues the plea colloquy by explaining the specific rights Mr. Nelson will waive by pleading guilty, including jury trial rights, the presumption of innocence, proof beyond reasonable doubt, and critically, the difference between appeals by right versus appeals by leave. Michigan Court Rule 6302 requires that before accepting a guilty plea, the court must determine that the defendant understands the nature of the charge and the maximum possible penalty, and that the plea is understanding, voluntary, and accurate. The rule mandates that courts inform defendants they are waiving constitutional rights, including the Sixth Amendment right to trial by jury, the Fifth Amendment privilege against self-incrimination, and the right to confront witnesses. Additionally, under Michigan law, defendants who plead guilty generally lose the right to appeal by right under MCR 723, which grants automatic appeal only from final judgments entered after a trial. Guilty pleas require permission from the Court of Appeals through an application for leave to appeal. The judge's colloquy directly tracks the requirements of MCR 632, methodically checking each box to ensure the plea will withstand later challenge. By specifically explaining that Nelson will lose his appeal by right and must instead seek leave to appeal, the judge addresses a common point of confusion. Many defendants believe they can appeal any conviction equally. The judge also probes for hidden promises or coercion, asking whether anyone made any promises to you as to exactly what the sentence would be, which protects against involuntary pleas induced by undisclosed sentencing guarantees. A defective plea colloquy can result in plea withdrawal years later, wasting judicial resources and potentially releasing defendants who have already begun serving sentences. The thoroughness demonstrated here reflects lessons from cases like People v. Kercheval, 1974, where the Michigan Supreme Court emphasized that plea agreements must be honored and defendants must enter them with full awareness of the consequences. For viewers, this illustrates how procedural safeguards protect constitutional rights even when defendants choose to waive them.
Has anyone made any promises to you as to exactly what the sentence would be in this case?
No, Your Honor.
All right, thank you. You still wish to enter the plea as we just discussed?
Yes.
As to add count 2, use of the controlled substance, amphetamines, and analogs. How do you plead?
Guilty.
Before the court can accept that plea, I need to have you tell me what you did that makes you guilty of offense. On a certain date, that would be July 1st of last year in the city of Cadillac here in Wexford County. What happened here?
I possessed a backpack that carried some utensils that had this substance.
Okay, you knew it was there?
Yes, Your Honor.
And did you have in your mind any lawful right to possess that substance?
No, Your Honor.
Did you do, you already said you knew it was there, and did you use it on or about that date or time?
Yes, Your Honor.
All right, thank you. Ms. Dahl, do you believe the defendant provided a factual basis?
Yes, Your Honor.
Are you aware of any of the promises, threats, or inducements?
I know.
You believe the court so far is in compliance with the court rule 6.302.
Yes, sir.
Ms. Cap, Hold on. Miss Castle's doing all the heavy lifting today. Do you agree with all those answers from Miss Dahl?
Yes, Your Honor.
If you're gonna have two attorneys, they may well both be involved. So, all right. The court agrees and finds that the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for that added count two. Therefore, the defendant is found guilty of that added count two, and count one and the enhancements will be dismissed upon sentencing.
Mr. Nelson provides the factual basis for his plea, admitting he knowingly possessed a backpack containing drug-laced pencils and used the controlled substance, establishing the essential elements for the misdemeanor use charge. Under Section 333.7404 of the Michigan Public Health Code, use of a controlled substance is a misdemeanor requiring proof that the defendant intentionally ingested or otherwise consumed a controlled substance. This contrasts with Section 333.7403's possession offense, which requires only knowing dominion and control over the substance. The factual basis requirement derived from Michigan Court Rule 64302-FF ensures that defendants cannot plead guilty to crimes they did not commit, protecting against coerced pleas and providing a record that supports the conviction if later challenged. Nelson's admission that he possessed a backpack that carried some pencils that had this substance and that he used it provides the minimal factual foundation required. The judge's questioning establishes the critical elements: knowing possession, the backpack, the nature of the substance, amphetamines in the pencils, and the use element that distinguishes this misdemeanor from the felony possession charge originally filed. The judge's finding that the plea is freely, knowingly, and voluntarily, with sufficient factual basis satisfies MCR 6302 and protects against later collateral attacks claiming the plea was unsupported by facts. The factual basis requirement serves as a critical backstop against wrongful convictions. In North Carolina v. Alford, 1970, the Supreme Court permitted guilty pleas where defendants maintain innocence but acknowledge sufficient evidence for conviction, but most jurisdictions, including Michigan, prefer express factual admissions. For educational purposes, this exchange demonstrates how even seemingly straightforward drug cases involve complex charging decisions here. The prosecution's willingness to reduce a felony possession with 15-year exposure to a misdemeanor use charge reflects the practical realities of plea negotiation and case resolution.
My intent here is to likely just sentence with time served as the offense that I just took the plea for, and then move to the sentencing on the probation violation. The only reason I would send it back and do another sentencing date would be if I was going to give them probation. But if I have it run currently, then it's going to be served. So, Ms. Dahl, any objection to that?
No, Your Honor.
Ms. Castle, we'll go back to you. Any objection to this process?
No, Your Honor.
All right, so now we're going to look here at file 13814, and we're looking at this probation violation report, which is also known to us as a CFJ 491. Ms. Dahl, have you taken a look at that report? And if so, do you have any corrections or objections that you think you need to put on the record?
I have reviewed it, Your Honor. I don't have any corrections or objections.
All right, Ms. Dahl, Ms. Castles, have you had a look at it? And if so, do you have any corrections or objections to make?
No, Your Honor.
After accepting the guilty plea, the judge announces his intent to impose a time-served sentence on the new case and proceed immediately to sentencing on the probation violation, with both prosecution and defense consenting to this consolidated approach. Michigan Court Rule 6.445 governs probation violation proceedings, requiring that the court provide the defendant with notice of the alleged violations and an opportunity to be heard. The CFJ 491 referenced is the standard Michigan form for probation violation reports, which must detail the specific conditions allegedly violated and the factual basis for each violation. Under Section 771.4 of the Michigan compiled laws, when probation is revoked, the court may impose any sentence that could have been imposed originally, making the stakes of violation hearings potentially severe. Even minor technical violations can result in maximum prison terms. The judge's consolidation of the new case, sentencing with the probation violation hearing, is procedurally efficient and legally permissible with party consent. By confirming that both attorneys have reviewed the CFJ 491 probation violation report and have no objections, the judge establishes the procedural foundation for the revocation hearing. The reference to running concurrently versus setting a new sentencing date reflects the judge's preliminary assessment that Nelson will receive a prison term on the violation, making probation on the new case pointless. Probation violation hearings receive far less procedural protection than criminal trials. There is no right to jury trial. The standard of proof is only preponderance of the evidence rather than beyond reasonable doubt, and hearsay is admissible. This lower threshold, combined with the original sentencing exposure, creates what critics call a sword of Damocles hanging over probationers. For viewers, this transition illustrates how the criminal justice system manages caseloads through consolidation, while highlighting the precarious position of defendants on probation, where even new criminal charges, regardless of whether they result in conviction, can trigger revocation and imprisonment.
Then let's go to allocution and we'll turn to the people. Ms. Dahl, the floor is yours.
Your Honor, I'm coming into this case a little bit late. My involvement in this case has been the probation violations. The court is obviously aware of this case from the start. So based on my review of his conduct on probation, his committing new offenses, him absconding, I don't believe he is a good candidate of probation any longer. He's had multiple violations. His guidelines are 10 to 23. I do believe the court has justification based on his performance on probation to go outside of the guidelines and give him more than that if the court chose to do so, but people are asking that he be sentenced to 23 months in prison. The court has given him chances of probation and given him an opportunity to get help, get treatment, get better, and he has continued to violate the court's orders. So I believe a prison term is appropriate in this case.
Ms. Castle.
Thank you. Your Honor, I would like to start by making note of the fact that Mr. Nelson has taken accountability for the mistakes he's made while on probation by entering the plea in this case that he just pled to. He's showing that he is admitting to it and he does firmly want to get back. He is expecting this prison term and he wants to make the most of it. He has plans for programming. I would like to note that he does have credit for 224 days. And based on this, we believe that it should be something within the guidelines, likely at the 18th.
All right, thank you. I should have also recognized Mr. Charles Kennard from the Michigan Department of Corrections. That office is the one that prepared the pre-sentence investigation report. All right, thank you.
The prosecution argues for a 23-month prison term at the top of the sentencing guidelines, citing Nelson's multiple probation violations, new offenses, and absconding, while the defense acknowledges the likely prison sentence but advocates for guidelines-range punishment and highlights Nelson's acceptance of responsibility. Michigan's indeterminate sentencing scheme, governed by Section 769.34 of the Michigan compiled laws, requires courts to calculate sentencing guidelines based on offense variables and prior record variables. The resulting range is presumptive but not binding. Courts may depart upward or downward only if they articulate substantial and compelling reasons for doing so, as required by People v. Babcock, 2007. The prosecutor's acknowledgement that the court has justification to exceed the guidelines reflects this legal standard, while her request for the top of the range represents a strategic position that acknowledges the court's discretion while advocating for severity. Ms. Dahl's argument tracks the statutory framework precisely. She identifies the applicable guideline range, 10 to 23 months, notes the legal basis for departure, multiple violations, absconding, new offenses, but ultimately requests a sentence within the range. This approach respects judicial discretion while making the prosecution's position clear. Ms. Castle's response accepts the procedural reality. He is expecting this prison term, but seeks to humanize Nelson through his acceptance of responsibility and future programming plans, mitigation factors that courts may consider even within a guideline sentence. The sentencing guidelines were designed to reduce unwarranted disparity, similar defendants receiving vastly different sentences, but they remain advisory in practice after United States v. Booker, 2005, rendered the federal guidelines advisory, and Michigan courts developed parallel approaches. The substantial and compelling reasons standard for departure ensures that guideline calculations are not mechanical, but incorporate individualized assessment. For viewers, this exchange demonstrates how sentencing advocacy works. Prosecutors emphasize public protection and prior failures, while defense counsel humanize defendants and identify positive factors, with the judge ultimately weighing these competing narratives against the legal framework.
Mr. Nelson, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say at this time, sir?
Your Honor, I think I have a little bit more than 300 days served.
At 324. Yes, sir.
I would be getting credit for them. And then,
If you want them.
of course, sir.
Anything else?
No, Your Honor.
All right, thank you. Mr. Nelson, this case originally involved a possession of methamphetamine case. And the court gave you 36 months of probation, 300 days in jail. And then gave you the opportunities at rehabilitation, and there was no discussion. That challenge, I spoke yesterday at a drug summit, a rehabilitation summit out at Baker College, and we talked a lot about treatment programs and how many cases involve controlled substances and the opportunities and how difficult it is for people who are struggling with substance use disorder. And so I'm not here to say today that you're a bad person for this offense or even some of the probation violations. It's just a symptom of the disease and how it spreads. At the same time, there's always this discussion about what do judges do. Do they give jail? Do they give probation? Do they give rehab? Do they give prison? And the answer is sometimes it's got to be a prison term. Because all the other efforts may have failed or they may not have worked. I don't like that word fail. So there are opportunities that were unsuccessful. I'd rather use that word. Failing sounds really negative. And I don't like calling it a problem. Controlled substances, drug addiction, things like that locally, they are opportunities for people to try to help. Programming.
Mr. Nelson speaks briefly to confirm his jail credit. Then the judge delivers extensive remarks acknowledging the challenges of substance use disorder, defending his prior efforts at rehabilitation, and explaining why prison has become necessary despite viewing addiction as a disease rather than moral failure. Michigan's sentencing statute, Section 769.34, requires courts to articulate the reasons for the sentence imposed on the record, including how the sentence serves the traditional purposes of punishment. Deterrence, protection of society, rehabilitation, and proportionate punishment. The judge's remarks demonstrate compliance with this reasons on the record requirement while also reflecting evolving understanding of addiction science. The judge's semantic choice, unsuccessful rather than failed, opportunities rather than problems, aligns with contemporary treatment-oriented approaches recognized in cases like People v. McMiller, 2020, where Michigan courts have increasingly acknowledged that substance use disorder requires medical intervention rather than purely punitive responses. The judge explicitly connects his sentencing philosophy to his recent educational experience at Baker College, demonstrating how judicial education influences courtroom outcomes. His recognition that Nelson's conduct changed from initial compliance to later absconding provides the factual predicate for the sentence. The judge's careful distinction: he is not punishing Nelson as a bad person, but responding to the symptom of the disease, attempts to preserve dignity, while imposing the severe consequence of imprisonment. This framing is legally significant because it shows the court considered rehabilitation as a purpose of sentencing, even while concluding that prison is now necessary. This judicial monologue captures the tension at the heart of American sentencing, the collision between recognizing addiction as a medical condition and the criminal justice system's limited tools for addressing it. The judge's visible discomfort with his own decision, I don't like that word, failed, reveals the human cost of sentencing discretion. For educational purposes, this illustrates how judges are not merely applying legal rules, but making deeply consequential moral judgments about human behavior, with the formal legal requirements articulating reasons, considering guidelines, providing structure for what remains an essentially discretionary decision about another person's liberty.
Even prosecutors and defense attorneys will often work together to help get a person into a rehab program. It's opportunities for us all to help those who are struggling with that issue. And I know that when somebody is under the influence of a controlled substance or even alcohol, they're not always in control of what they're doing, or at least it impacts them and changes them. So I don't want you to think that I look at this and say, oh my gosh, Mr. Nelson's the person here, but you're struggling. I don't know what else to do. We've had a lot of opportunities here, but I hope that you continue to find opportunities. Prisons, they've got rehab programs, they've got trades, things like that. I know it's not great, but I really want you to know I care. I really hope that someday you come back here to the office and say, hey, Judge, I did one. I need help. Where do I go? I'll tell you where to go. I'll help you get there. And I also hope that you come back and say, hey, Judge, thank you. You don't have to say thank you because no one likes us to be sent to lock up, but I want to see that you come back. You got a lot of life here to live. I'm sure you're younger than I am. So, all right. Anyways, I really hope that you get this figured out. All right, in file ending in 199, the court sentences the defendant as follows: a $50 state minimum fee, a $75 crime victims' rights fund fee, a $150 court cost, a $150 attorney fee. Therefore, there's no supervision fee. I'm not going to assess and the court sentences the defendant to 38 days with 38 days of credit. The arrest didn't take place or wasn't counted until January. Got it. I think it might have been the 16th or whatever. So I'm just giving you credit. That sentence, therefore, will run concurrent, but in effect, it's already been served. You got the old case.
The judge concludes his personal remarks to Mr. Nelson with encouragement and an unusual offer of future assistance, then formally imposes sentence on the new case. Time served with various statutory fees, running concurrently with the probation violation sentence to follow. Michigan's sentencing fee structure is governed by multiple statutes: the $50 state minimum fee under Section 769.1J, the $75 crime victims' rights fund fee under Section 780.905, and discretionary court costs under Section 769.1K. The judge's decision to impose time served reflects the common practice of crediting pre-sentence detention against the sentence imposed, authorized by Section 769.11b. The concurrent sentencing, allowing the 38 days to run simultaneously with the longer probation violation sentence, ensures Nelson receives no additional custody time for the new offense, a typical resolution when the primary sanction comes from the violation rather than the new conviction. The judge's meticulous enumeration of fees demonstrates compliance with statutory requirements, while his decision to forego supervision fees reflects the practical reality that Nelson will be in prison, making community supervision impossible. The 38-day sentence, matched by 38 days of credit, effectively nullifies the new case as a separate punitive event, focusing all incarceration on the probation violation. This sentencing structure plea to reduce charge, time served on new case, prison on violation is a common global resolution that provides finality for all pending matters. The judge's personal offer, I'll tell you where to go, I'll help you get there, while well-intentioned, highlights the limitations of judicial intervention in substance use disorder. Research consistently shows that recovery requires ongoing support, not one-time judicial encouragement. The fee structure, meanwhile, illustrates how even time-served sentences impose financial burdens that can follow defendants for years, potentially creating barriers to re-entry. For viewers, this segment demonstrates how sentencing involves not just liberty deprivation, but also financial obligations and, occasionally, genuine human connection across the bench.
Now, in the older file, the one for which we're talking about this probation violation, which is file 13814, the court revoked probation unsuccessfully, preserves any unpaid fines and costs, and the court sentences the defendant to a prison term that will be 20 to 120 months, and the court, of course, gives the defendant jail for 324 days. That only accounts for the days that you've actually sat in jail. It doesn't account for any good time credit, which you get to keep, and that will be added to that. It's not just 324, it'll be higher than that. If you served 300 days before, for example, it should be a number. Anything that I've missed, Ms. Dahl?
Not that I can think of.
How about you, Ms. Castle?
No, Your Honor.
Ms. Getz, how about you? Do you think I get it all?
You got it all again, Judge. Thank you.
Mr. Kennard, anything that I missed?
No, Your Honor, thank you.
Samantha, do you have an advice and rights form over there? There should be a new one signed by or there will be on there. You get Ms. Castles, Ms. Getz. You were on the monitor here in the courtroom right above Samantha's head. Samantha's new at this job. So if you could all just like look down, kind of like in the Brady Bunch there, see? Now they're looking down at you, Sam. You feel the pressure? Yeah. All right, ladies, thank you. You don't need to look down. All right, so if we don't get it to you right now, Mr. Nelson, somebody will take care of it, probably somebody from the Department of Corrections. You have the right to appeal your conviction and sentence in this case. That is done by filing a claim of right, an application for leave to appeal because of the original plea and guilty. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you will complete a copy of this document that we are hoping to get to you here today and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Do you have any questions about your rights to appeal?
No, Your Honor.
Do you have any questions about what we have done today?
No, Your Honor.
All right, Mr. Nelson, let's look at this as an opportunity.
Have a great morning.
Thank you, ladies. Nice to see you all. We're adjourned.
Approach, Your Honor.
Yep. Oh, yeah. Yep.
Thank you, Your Honor.
Mr. Nelson was sentenced to 20 to 120 months in prison for his probation violation, with 324 days of jail credit applied toward that sentence. On the new drug case, he received time served 38 days with various court fees totaling $425. The judge revoked probation, preserved unpaid financial obligations from the original case, and encouraged Nelson to use his prison term for rehabilitation and programming. Nelson declined to speak further and confirmed he understood his limited appeal rights. This case illustrates the profound discretion embedded in American sentencing and the human consequences of its exercise. The judge's evident ambivalence, imposing a 10-year maximum prison sentence while expressing care and hope for Nelson's recovery, captures the central paradox of criminal justice responses to addiction. The system recognizes substance use disorder as a medical condition, but lacks sufficient treatment infrastructure, leaving incarceration as the default response to repeated violations. Several legal principles converge here. First, the plea bargaining process, governed by Michigan Court Rule 632 and constitutional due process, enabled resolution of multiple cases through charge reduction and consolidated sentencing, an efficiency that benefits courts and parties but requires defendants to waive fundamental trial rights. Second, Michigan's indeterminate sentencing scheme, with its guidelines range and departure standards, provided structure for the judge's decision while preserving ultimate discretion. Third, the probation violation framework, with its lower procedural protections and exposure to original maximum sentences, creates powerful incentives for compliance that, as here, can result in severe sanctions for continued struggles with addiction. The judge's semantic reframing, unsuccessful not failed, opportunities not problems, reflects growing judicial recognition that language shapes outcomes in criminal court. Yet the sentence imposed, however compassionately explained, still removes Nelson from his community for years. This tension between rehabilitative ideals and punitive realities defines much of modern criminal law, inviting continued examination of whether our institutions are structured to achieve the outcomes we claim to desire. If you found this analysis valuable, subscribe for more educational court case breakdowns. Share your thoughts in the comments. Should addiction-related probation violations receive different treatment than other violations? What resources do you think would help judges make these difficult decisions? Your engagement helps us continue providing accessible legal education.